All right, let's do a video on the Rittenhouse trial. Alexander, this is our first video on this, but yesterday, what a day in the trial. We had the second day of jury deliberations. We have no verdict. We're expecting a verdict, but so far we don't know what's going on. Obviously, people are concerned because the general thinking is, and you can weigh in on this, is that the longer it takes for a verdict, the worse it is for Kyle. Usually, if the verdict was quick, it would mean that it would be a sure acquittal on all counts. But we'll see. We don't know. We can't predict anything, and we have to see and wait. And we'll see what happens. We had a second mistrial motion from the defense. The first mistrial, I believe, was with prejudice, and the second mistrial that they put forth was a mistrial without prejudice. You may want to get into the differences there. But finally, just to give you the reasons why they called for a mistrial and why everything was crazy yesterday, it really had to do with the drone footage of the incident, which at first during the trial was a low quality drone footage video. And then the prosecutors came out with a high quality, high definition drone footage. And the defense didn't have time to prepare properly to answer some of the questions that came out of that high quality drone footage that the jury also wanted to review over and over again. The jury requested to see that video as they were deliberating, which is also, you'll talk about that as well. But the technology part of this, which I'll weigh into right now, is that the prosecutor, James Krause, obtained this high definition drone footage as the trial was going on. It was passed on to Rittenhouse attorney Natalie Wisco. Now, what we found out yesterday is that when Wisco got her copy of the video, the file was compressed. She kept on saying milliliters or megabytes is what she meant as she was explaining herself. But I forgot the exact number. Say that Krause's file was 100 megabytes, and Wisco said, well, ours that we got from them was only 20 megabytes. So then Krause gave this long-winded explanation that, well, I got it, and it was from an iPhone, airdropped to an Android, and there's this compression that happens, and that's why your file was compressed. Well, Natalie Wisco and the judge let Natalie Wisco explain how she obtained the video footage. She said, yes, it was compressed, but Your Honor, when you look at the names of the files, they're different, i.e., Krause's file name was 1234. Once again, I'm just making something. I forgot the name, 1234. My file that he passed out to me was XYZ. So how did that happen? Did he change the name of the file? Is it indeed the same file? Did he change the name of the file? Krause didn't have an answer for that. And then Wisco also mentioned that the metadata was different. She mentioned that Krause's file had metadata with a certain date. Her file had metadata with a date that was 20 minutes past the date of Krause's file. So one is led to believe that Krause made a copy of this video 20 minutes after the fact, and that this is not the original video. Finally, when we saw Krause's computer, it was pointed out by many YouTube viewers that his computer had a program called Handbrake. Handbrake is, I know Handbrake, I use Handbrake. Handbrake is used to compress files, to change the codecs, to change file extensions in videos. So it's used basically to manipulate videos. And Krause is saying this was done from my phone and it was a simple airdrop. That doesn't seem to be the case. I mean, when you look at all the technical sides of this, my expert opinion on this is that Krause is lying. When you compress files, when you send files, the name doesn't change unless you change it. The sender actually changes it unless the sender manipulates it. The fact that the metadata is different as well, this is bad news for the prosecution. Anyway, I wanted to give the technical context to this. The rest is yours, and that's where we are. That's where we are today.
Indeed, I mean, it doesn't look good. I mean, can I just say this problem has been riddled with this trial has been riddled with problems. I mean, there've been times when the prosecution was struggling with some legal issues. They brought a claim on firearms on firearms issues, which the judge has already thrown out. And there's been serious problems with much of the witness evidence, which doesn't seem to have been as the prosecution expected. But we now have on top of all of that the fact that this information, this very important information, which the prosecution is relying upon, was sprung upon the court and the defence at literally the last moment in the trial. There was no opportunity, therefore, given to the defence to examine and to work on this evidence properly, and the prosecution at the same time, as well as springing this evidence at the last moment, also arranged for the defence to be given a, shall we say, less, well, a compressed, an almost unusable version of this evidence, which made it much more difficult for them to prepare a response. Now, I have to say, that looks like the kind of trick that you read about in Perry Mason novels, not in real proceedings. It looks extremely shabby, and it looks to me like a prosecution pulling out tricks, coming out from a sort of, frankly, sleazy bag of tricks in order to get what they want, which is obviously a conviction. And this has happened in the same context that we've had this blaze of media publicity about the case, this heavy pressure on the jury, who were not sequestered. That I find is remarkable, by the way. So they're well aware of what's being said all around them. And I have to say, I'm not surprised that the defence has sought to have the case dismissed. A mistrial without prejudice, as I understand it, would mean that if the judge were to accept that, he could not be tried again. He would walk free, because the whole case would have effectively collapsed. A mistrial, just a simple mistrial, might leave open the opportunity for another trial further down the road. So it would mean starting again, but presumably and hopefully in a rather more orderly form than the one we have at the moment. I would say that even as things stand, I would have thought that if there was a conviction, then there would probably be an appeal, and that there are now many appeal points, including appeal points about this evidence and whether this evidence was admissible or not. But we will see whether that happens. I, by the way, would not be so quick to say that simply because the jury are taking a long time, that means necessarily that they're going to find for a guilty verdict. In my experience, what it often shows is that there's been dissent and argument on the part of the jury, and it points more to a split jury than anything else. But, we'll just have to see how things turn out.
It looks like the prosecution tampered with evidence. True?
Well, what they've done is they've produced incomplete evidence and done so knowingly. Now you can knowingly. Now you can. It's absolutely. Now you can call. Now, I mean, that is, to be straightforward about it, that is extremely bad. I mean, that's not what should happen in the course of a trial. It's as I said, it's to say that it's sleazy is to use extremely measured language. I'm using very measured language, taken to an extreme. And the judge has hinted at this. It's downright contemptuous. And when I'm talking about contemptuous, I mean contempt towards the court and towards the judge. I mean, the prosecution has, at various points over the course of the trial, appeared to override the judge's own rulings about admissibility. What it shows, and again I'm using very careful language, is a very ruthless approach to the conduct of this case by the prosecution, one which shows, shall we say, a reckless attitude towards court protocols and towards the concept of fair trials. We'll see what happens. As I said, if there's a conviction, I would have thought that there would be multiple grounds for appeal.
Does it worry you that that they're deliberating for so long, or
No, as I said, it
who
doesn't.
knows?
It doesn't necessarily. As I said, what it does point, and I always expected this, that there would be, given the context in which this trial is being conducted, it seems to me that what it points to more than anything else is disagreements within the jury group. But
In which direction do you think usually?
Well,
not what do you think usually? What's the case?
That is impossible to say. I mean, that is absolutely impossible to say. I mean, I don't think one can say.
If you had to guess, you get betting mad.
Right.
Yeah, just take a guess. An educated guess. What do you think? Because I've heard both sides. I've heard,
yes,
10-3 in one direction, 10-3 in the other.
Another direction.
If it's 13. I'm not sure of the number. Anyway.
Right. I mean, I am going to guess that it's probably 10-3 for conviction rather than acquittal at the moment. But, if three jurors stand their ground on the basis of what they've seen in court, then I'm not sure that this case can. I don't know that the judge can accept a majority verdict in a case like this. I would guess not. In which case, the whole thing would collapse and we'd have to start again. I am absolutely incredulous that this jury was not sequestered over the course of this trial. I know many lawyers are unhappy about it, and Alan Dershowitz has come out and commented about the fact that it was extraordinary that the jury were not sequestered.
Yeah, I don't know if it's anyway. We're just using the number 10-3, but you would say that a majority of the jurors actually now buy into the fact that this wasn't self-defense. That's astonishing to given everything that we saw, which would then lead me to believe that the media, the threats, the protesting outside the courthouse, all of this stuff has played the biggest role in all of this.
Right. Now, I want to again stress this is a guess.
A guess.
And I might be completely wrong. I mean, I wouldn't put too much weight on it. But the reason why I would guess in that direction is obviously we've had a trial, which is a relatively short affair. But we've had a massive lead up to that trial with some very, very, shall we say, unobjective and very strong coverage in the media, on television, in newspapers, on social media, all sorts of calls, all sorts of claims, all sorts of things like that. Now, in my experience, it would be very difficult to get a jury simply to put all that aside over the course of a trial. And also, especially so if they've not been sequestered, which, as I said, seems to me extraordinary and very remarkable. Maybe it's not the law in Wisconsin, but all I would say is I think if it's not, it should be. So given that, I would have thought that it's more likely than not that when the trial began, some of the jurors, probably a majority of the jurors, went into the trial with their opinions about the case largely formed. Then the trial would have taken place, they would have heard evidence, and it's more likely than not, these are guesses, that some of the jurors, seeing what happened over the course of the courtroom, the course of the hearing, would have gradually peeled away. But it's likely, or so I think, that a majority of the jurors at the moment would still be wedded to their earlier, previously formed, previously established opinions. What's probably then happening, and this is very typical of juries, is that there's a big argument with some of the jurors, probably the jurors who now lean, if my scenario is the right one, towards acquittal, trying to point out and explain why, and meeting some resistance and incredulity on the part of some of the other jurors. And sometimes what happens is that either the jury simply can't decide, or gradually some of the jurors, the more reasonable ones, are won over. So it's difficult to say what the dynamics would be. But I'm going to make one observation. I never thought that the jury would make its decision quickly because of the overall context in which this case took place.
Yeah, and it could be totally in the other direction too. We don't know.
And it could be
so hard to call.
and it could be totally in the other direction. I mean, what I'm saying, as I said, is purely a guess. I don't want, and I don't want anybody running away and saying that this is my opinion of what's happened. It's just what I think is more likely than not. But I wouldn't put money on it one way or the other. It's never easy to try and guess what juries think.
Yeah. The judge. You think the judge understands that this was self-defense? I mean, it seems to me the judge understands. Any normal thinking human being understands this was self-defense, given everything we've seen. But do you think the judge wants this to either be a mistrial or he wants the acquittal? And if there is a guilty, he's going to probably move this towards a mistrial. I mean, my question is, do you think the judge wants justice to be done?
I think the judge is utterly exasperated and antagonistic, and has become increasingly antagonistic over the course of the case to the prosecution. I think he's very upset by the kind of media coverage. I think he's very upset by the way in which the case was conducted overall. And I think that the strong indications are that he is heading in that direction. So we will see what he does.
Mm-hmm. Even if the worst outcome happens for Rittenhouse, it seems like he has a very strong appeal.
I would have thought so. I would have thought so, purely based on the evidence before the court. Now, again, I have to be very careful because obviously my knowledge is about the legal process in Britain. And, I'm not familiar with Wisconsin procedures and Wisconsin law. But I would have thought that there would be a good argument for saying that the decision, if it ended in a conviction, was so obviously contrary to the weight of the evidence. I mean, the prosecution's own evidence, and that there were so many problems with the way in which the prosecution presented evidence to the court, which, as I said, was at times borderline contemptuous, that I think you could argue that the trial itself, that there were real problems about the fairness of the trial. So I think at that point, on appeal, there would be a real prospect of the decision being overturned. But we'll just have to see what happens. And as I said, Wisconsin, I mean, there are the internal politics of Wisconsin itself and how courts function within Wisconsin. And I presume that any appeal process would be within Wisconsin and under Wisconsin laws rather than at federal level. So, I think there probably would at some point be an appeal to the federal courts, but I think we'd be a long way from that point initially, at least. So, let's wait and see. But I certainly think there would be an appeal process if there was a conviction.
Yeah. Do you think the media has already won? Do you think they're going to get the riots that they're definitely looking for riots? They want riots. You think they're going to get the riots that they're pushing for? You think that they've won in the narrative that this is somehow related to race, which it makes zero sense. But hey, they did it. They managed to convince people this is about race, that he's a white supremacist. I mean, they've succeeded in that. But I mean, yeah. What do you think about that? Because no matter what happens now going forward, it seems like the media they're going to get what they want.
The media coverage has been appalling. And that isn't just my view, it's the judge's view too. So, I mean, I think that the media have, to an extraordinary degree, misframed this story, this case. And that's had a very, very great and very damaging effect. And I'm going to say,
did it on purpose.
Can I just say, whatever happens, I think they've achieved their objective. Because if he's convicted, they will say, well, he was convicted because he was all the terrible things we said he was. And if he's acquitted, they will frame that again as part of the narrative. They will say that it's part of the bias of a judicial system which is riddled with all the prejudices that underpin the whole law enforcement system in the United States. So I think that the media have successfully framed this story, and whatever the outcome is, I think they've achieved their purpose. But of course, the effect of what they've done, quite apart from the effect it might have on the outcome of the trial itself, but the effect of what they've done is, in my opinion, they've undermined the legal system of the United States, and they've intensified partisan feeling in the United States, because what they've achieved is to make people on either side of the political divide over this case feel even more entrenched and embedded in their views than they would have been otherwise. So instead of having a trial operate as a healing process in which the evidence is presented, the jury reaches a decision, people are able thereby to come away and feel that the correct decision was reached. Whatever happens now, each side of the political divide will take what they want from this case, and that will intensify and fuel partisan feeling even further. That undermines the judicial system of the United States and its authority. It undermines political stability of the United States, and it also undermines trust in the media itself. But at the moment, they don't seem to care much about that.
That's their goal. Undermine the Second Amendment, undermine the Constitution, undermine the legal system, create division. I think that was their overarching goal to all of this, and they've accomplished it. The misinformation was extraordinary coming out of the media. Extraordinary misinformation. I don't see them getting deplatformed or canceled or anything like that, even though, I mean, their lies were just beyond the pale. But they do this over and over and over and over again.
Well, absolutely. Can I just say, I mean, I was reading yesterday a rather interesting article. I mean, I thought interesting article about Russiagate in the New York Times, of all places, and about the Steele dossier. And, trying to edge away, we've got a few things wrong and that sort of thing. But no contrition, no acceptance that the entire narrative that they framed was wrong, or their responsibility for framing their narrative in that kind of way. Because, to be straightforward about it, their attitude has become increasingly reckless with respect to reporting the news objectively. That's no longer what they're about anymore. So they did it before, and they've done it again with in this case, and they're going to do it again in future, and they're going to do it more, because they have now become essentially part of the partisan divide themselves, which is, as I said, undermining trust, because the people of the United States look at the institutions of the United States, and the media is an institution of the United States. It has protections granted to it by the First Amendment, and they no longer trust those institutions.
Yeah, and they're protected by big tech. So they don't really care what the people think.
Of course they do.
They know that big tech will protect them, so they can push out and distribute any lies that they want. And big tech will amplify those lies.
Absolutely. And suppress anybody who contradicts them, as it's shown that it's prepared to do, and will suppress any story that contradicts the media narrative, as it did with a certain person's laptop, for example.
Yeah. That's why when you get more and more news stories like this, the media is just more and more emboldened. I mean, the lies are getting worse and worse, bigger and bigger, because they're just not accountable to anybody anymore.
Well, exactly, except, of course, as I said, that people become increasingly alienated and trust declines. And, of course, you then get all sorts of concerned articles from all the usual suspects about the way in which trust is declining, and why is this so, and why don't people believe us anymore? Well, it's because of what they do.
Yeah. Do you think we're going to get a verdict quickly? Do you think we're going to get a verdict soon?
I think we will get a verdict soon. I don't think this will run and run. If it does, I presume that the judge will intervene, and he'll call in the jury and ask for some explanation of why it's taking so long. So I would have thought we will get a verdict soon.
All right. I better get this video up. All right. Guys, at Duran.locals.com, and go to the Duran shop. 10% off. Use the code RealNews. Rumble, BitChute, Super U, and Odyssey. You'll find our videos there as well. Take care.